A procedure has not been followed to do a proper arrest as being given in section 41, then accused get all the right to get discharged from the particular case or get a bail immediate. A procedure is not followed. I'll give an example like NDPS Act. Suppose I'm giving a broad example of Narcotic Drug Act, where they have said that if at all they want to seize the drug, the officer should be above rank of ACP. And many of them only officers of lower rank do the seizing part, and that is maintained in Panchnama. Only on that one ground, whole Panchnama get vitiated and accused get acquitted in a case. Another case, like let me give example with criminal liability in medical sciences. If you see overall scenario in medical sciences, because of the procedure followed as laid down in Honorable Supreme Court for arrest of a doctor, it takes a longer time to file a charge sheet by the police officer. Now, what is the guidelines given in the case? That if at all you want to arrest any doctor, the following procedure must be followed. And what is the procedure? Procedure says that first it need to be sent to expert committee for opinion. Once expert committee opinions on a medical record and after investigation that there is a negligence on the part of a doctor or a medical practitioner or RMP, then they can be arrested. And then police officer, after completing this procedure, they arrest a doctor under 304A or whichever section. And thereafter, we follow the bail, trial, and other things and all. The whole procedure is being given under the CrPC, and how the methodology and system should go accordingly been guided under the Act. Now, to make you understand why I am talking much about CrPC, I'll give an example with medical sciences. Many of the time, it is my observation that 304A is booked after a year or two because committee opinion comes after 6 months or a year. By the time, lots of changes happen. And then many of the time, complainant is not available. I've seen in multiple cases where when the onset of or cause has happened, like death has happened, the relative may be very aggressive, they may file the case, and thereafter they don't follow the case. Or in case of postmortem, the procedure which has been set to ascertain a cause of death, like procedure of ADR says, ADR is accidental death report. If there is no cause of action known or cause of death is known to the doctor, they refer it to the police officer for doing postmortem of particular body, a dead body, to ascertain the cause of death. And for that procedure is very clear that police will take over the body. Like suppose death has happened in your client's clinic or hospital. You need to immediately inform a police officer. Once police officer comes, the role of doctor is over because they hand over the body to police officer. Now, police officer takes the body by doing inquest panchnama. Inquest panchnama means that time, that particular period, the panchnama which is made of the body in front of the police officer and the statement of the relatives takes, and then ADR get filed. ADR means accidental death report. Since the cause of death is not known, it is a natural or unnatural. The prima facie ADR file get filed by the police officer. Once it turned out to be natural death, then police officer closes the ADR file by reporting the same. If it turned out to be unnatural death, then police officer reinvestigate the matter to reach to the accused. If it is a medical accident, then it referred to the expert committee. And once committee opinion comes, then police officer proceed for filing FIR. In such a cases, many of the time we have found that since the period is very big, either is ADR filed and complaint has not come again, or complainant at initial phase was aggressive but later never turned up. So 1 year later, they don't get a complainant. I found many of the cases where complainant, the police officer himself become the complainant. And once police officer become the complainant, and same police officer does the investigation. In majority of cases, if FIR comes to you or charge sheet comes to you and you read the charge sheet, if complainant name is Mr. Bosley and the investigation officer's signature is same of Mr. Bosley, then this case is for you. Without any hesitation, you can win the case in any court of law. Reason is very clear. Law very clearly says that If investigation officer and complainant is same, then investigation is going to be biased because complainant definitely wanted to put all the evidences in his favor because he himself is a complainant. So in trial court, it is presumed that evidences which may be in favor of a patient or the accused may not have been taken by the prosecution officer with malified intention. So that becomes a ground to quash the case altogether. And that is the reason why I say investigation officer must not be a very simple a complainant. These are the things which has been taught under CRPC. CRPC again give a very clear idea about complete procedure of a criminality. Like once offences happened, as I said, death has happened on table. Police officer was involved. Inquest Panchnama was done. ADR file has been filed. Committee opinion has been sought. Thereafter, if at all committee opinion comes against the doctor, then FIR gets lodged. FIR is the first information report. Now, once basically FIR is lodged by the informant, that means the complainant who are actually victimized. So once FIR got filed, then police officer FIR, then they need to make the section and other things and all. Then police officer start the investigation. Now there is a time period given under the CrPC, time period of 2 months, 60 days in all cases, majority of cases, and 3 months in a very heinous crime like rape and murder. Again, the CRP has given the time limitation period for filing a charge sheet, and further it is said that if charge sheet is not filed on time, that means 2 months, then accused by default get the opportunity to get a bail. So there again, no effort need to be taken by the advocate because criminal procedure code itself help them to get the bail. So that is where procedure plays a vital role. Not only that, once FIR get filed, then charge sheet need to be filed within 2 months. When charge sheet is filed, then accused have to present it every date on the court of law, followed by the trial. The trial means the authenticity, the proven thing of that particular charge sheet in a court of law. Because whatever we mentioned in charge sheet cannot be read and understood as evidence unless it is deposed in front of a judge. So that's the reason, majority of time it is said, whatever statement given in front of a police has got no value unless it is proven in court of law. So during trial, what happens? Each and every witnesses who has given their verdict and version about the case, like suppose patient relative has a complaint, other relative has taken a statement, he narrates the complete story when he has taken to the patient to the hospital, who had examined, how surgery was done, what exactly happened. Timely, everything has been recorded in the statement, and the same thing during the trial court. If at all the witnesses don't depose it, and it varies from the writing and the oral, then such a statement is not accepted in court of law. Hence, the benefit always goes with accused. This is the process of CrPC and then evidence, further what we are going to understand. Again, after the trial, there is a multiple sections which we are going to learn. Like one of the section is 313, which after completion of trial, opportunity was given to accused to say whatever he want to say for his defense. Under section 314, they have been empowered to call their own witnesses also to prove their cases. So these are the procedures, and thereafter naturally the order. Order under the section will come if it is against the doctor or against your client. Then further procedure code has said that one can appeal to higher court if they are not satisfied with the order of the lower court, and hierarchy of the courts has been given. So in that way, procedure helps in every ground. In between, like section 437, 438, 14, and all talks about the bails. What is the procedure about the bail? Who all can opt for the bail and who cannot? What is the procedure under the billable offense? What is the procedure under non-billable offense? How after the bail people and accused are going to be released and how they need to be present themselves during the trial. What is the role of the conviction? Anything and everything has been very, very clearly defined under the Act. Act has gone to the step ahead. When they talked about the arrest, done the latest amendment of 2013, when the parliament and the lawmaker has found that lots of under trials are remained in the jail, even for the frivolous offences, even the smaller offences, and jails are full with accused. Parliament has came out with a new amendment under CrPC in 2013. And what Parliament has done by amending this law, they have blocked the arrest of all the people below 7 years. And the new amendment under 41A, capital A, very clearly has defined ABCD, the foreground for the arrest. And they said any punishment which has got punishment up to 7 years. So almost 80 to 90% section is below 7 years. So 80% has gone. The section having punishment up to 7 years, accused must not be arrested immediately. And law says that first notice may be issued to these people for their version as an investigation part. And if at all police officer feels that no, it is essential to arrest the guy by writing reason, they can definitely arrest. But once they have released the notice under 41A, they need to see that accused are coming. And further, C says, if accused has came properly on a date called by the police officer, then they must not be arrested. Taking ground of 41A, my friend, I have taken a loss of bail in the country.